The National Environmental Policy Act requires federal agencies to consider the environmental impact of proposed projects before approving them. In Robertson v. Methow Valley Citizens Council, the United States Supreme Court considered just how detailed an environmental impact statement needs to be. Methow Recreation applied for a special use permit to develop a ski resort on Sandy Butte, a mountain in Washington's Okanogan National Forest. The Forest Service prepared an environmental impact statement, or EIS, that considered the impact the development would have on the natural environment. This study identified measures that could mitigate air pollution and concluded that the development would have little impact on wildlife in the area, including the mule deer that use the Methow Valley as winter range. The Forest Service recommended that Methow be granted a permit while directing that the parties implement certain mitigation measures. The Methow Valley Citizens Council and 3 other organizations that opposed the development sued Forest Service Chief Dale Robertson under the Administrative Procedure Act. They claimed that the study didn't satisfy the requirements of the National Environmental Policy Act, or NEPA. The magistrate found that the study had adequately disclosed the impacts of the development on the deer and air quality. The Court of Appeals reversed, holding that the Forest Service couldn't rely on future mitigation measures to conclude that the impact on mule deer would be minimal or that air quality would be unharmed. The court concluded that the Forest Service had an affirmative duty to develop the mitigation measures before the permit could be granted. It also held that the Forest Service should have analyzed the worst-case scenario before approving a permit. The United States Supreme Court granted cert.